Yes, Your Lordship. Your Lordship, I beg to mention item number 8 on behalf of the petitioner.
Number
8.
8.
Yes, Your Lordship. Connecting counsel, he is on leave.
Who's for the
First, no objections, my lord.
So, how long?
For 2 weeks, Your Lordship.
On pre-made by the petitioner. This is matter to 2 weeks.
Did Your
Right.
Lordship.
Yes.
Wait, please, Your Lordship. I beg to mention item number 2, Your Lordship.
Why? Yes, this matter, I think we have decided that will be taken up.
Yes, Your Lordship. Your Lordship, actually, the learned DSGI is stuck in traffic, Your Lordship.
We'll take it at the end of the board.
Your Lordship. Much
I
obliged.
don't think it'll take him that long to appear.
Okay, Your Lordship.
Maybe in half an hour's time he will be here. We'll see.
Your Lordship, I beg to mention item number 9, Your Lordship. Number 9, sir.
Yes.
Your Lordship, I pray if this matter may come up after 2 weeks, Your Lordship.
You are for?
I'm for the respondent, Your Lordship.
What about the petitioner?
Sir Vipin Kumar from
Yes,
Guwahati.
so? They are here.
Your
Have you
Lordship.
informed them?
No, Your Lordship.
Let the matter be called up. Then you, at that point of time you can make a mention.
Your Lordship. Lordship, item number 11. I've already informed the other side, Your Lordship.
Yes.
Lordship, I am for respondent, Lordship.
You are
1
for
and 2, Lordship.
1 and 2.
Yes, Lordship.
How long?
2 weeks, Your Lordship.
On pre-made by the petitioner. This is matter to 2 weeks.
Much obliged, Lordship.
Obliged, Lordship.
Right, please, Your Lordship, I beg to mention item number 10.
Number?
10, Lordship.
You are for?
Respondent number 2, Your Lordship. Lordship, let this matter come up after 1 week due to personal difficulty of my senior Lordship.
This is a small matter for CMJ to reconsider their certificate.
Your Lordship, I am for the respondent number 3 and 4. Your Lordship, my senior is not well. He's under treatment in legal rooms. So we are praying for 2 weeks' time.
Come after vacation then.
Yes, Your Lordship.
On pre-made by the respondents. Not objected to by petitioner. This is matter after puja vacation.
Very much, Lordship. Your Lordship, I would like to beg item number 3 as well, Your Lordship. Lordship, I had already informed the other side. Lordship.
Lordship, I'm appearing on behalf of respondent 1 and 2.
Lordship, we had made on joint request. I would like to let this matter come after 2 weeks, Your Lordship.
On pre-made by the parties. This is matter to 2 weeks.
Lordship, I would like to mention item 3 and 4 as well, Lordship. Oh, 4 and 5, Lordship.
There's nothing left.
Yes. 4 and 5, Lordship.
There's also 2020 matter.
Yes, Lordship. But due to personal difficulty,
Informed that he'll be leaving shortly, so he's asked us to move this before this honorable bench. It's a second appeal. There is extreme urgency in the matter.
What is there in second appeal?
The urgency, my lord, if I can just take 1 minute, this concerns the golf course. Now, golf course land is under the control of the Shillong Club. We've taken it on lease from different clans of Meghalaya. Now, one of the clans tried to take back a portion of the golf course a few years back, unilaterally, my lord. We filed a title suit. Title suit was dismissed. We filed a first appeal against the dismissal of the title suit. First Appellate Court, Additional Deputy Commissioner's Court, 2 days back passed a judgment dismissing our appeal. But while dismissing our appeal, my lord, surprisingly, came to the conclusion that Transfer of Property Act does not apply. So therefore, our original lease deed itself was an invalid document in the eyes of law. We have no lease deed. So today what is happening is the respondents have informed the headman, the Dorbashnong, that they'll be coming to take physical possession of the golf course. So there is extreme urgency because of the unavailability of Justice Thankew's bench. We've been constrained to come before this honorable bench with the request that we may be allowed to move this.
But in the second appeal, I don't know.
My lord,
You know very well. You see what are the
there are substantial questions of law which we have formulated.
parameters are, under which
Absolutely,
the second appeal can be taken up.
absolutely, my lord.
Firstly, issue of law has to be decided.
Absolutely, my lord. So,
Preempt.
so the primary issue of law which will come up for lordship's consideration is, does the Transfer of Property Act apply in the state of Meghalaya, especially vis-a-vis pre-independence times? So because the finding of the lower court,
That has happened. So, see, I think prior to 1972, it would not apply.
no, my lord, the position of law is different because the finding of the appellate court, the first appellate court, is TP Act does not apply, would not apply before independence. Therefore, your document, the original lease document itself, is an invalid document. Now, no one had asked the first appellate court to adjudicate that issue. There was no cross appeal. So the question of law that falls for lordship's consideration is, does TP Act apply in a pre-independence time, my lord? And that's a very substantial question of law.
And in any case, you see, why would a situation arise where the degree holder
Yes,
would assume possession of the land or whatever, or take over possession
that's
in absence of an execution proceeding?
no, that's exactly the point, my lord. They're not even a decree holder. They did not file a cross suit, a counterclaim, or a cross appeal. But however, to create confusion on the ground, in 2015, when my suit was dismissed, they tried that. They bought a JCP to the land and tried to take physical possession. Police got involved, but there was a stay from the first appellate court. Today also, they will try the same thing, to take physical possession. Once they're in physical possession, it becomes extremely difficult to get them out of possession in spite of the pendency of the matter. So because of that urgency, my lord, if lordship is indulgent and allows us to move this appeal, we'd be very, very obliged.
Is
My
there
lord.
any caveat?
And there is a caveat. My friend is here.
Your Lordship, we have just received only the soft copy, Your Lordship.
We'll give them a hard copy. We've given them a soft copy because we got the judgment last night. So we prepared the appeal last night itself. We gave them a soft copy of the appeal. We'll immediately give a hard copy.
Let this matter come after a week. Your Lordship.
Let me at least move the matter, my lord.
Yes, agency, we'll have to look at it. Fine.
Highly obliged, my lord. Highly obliged.
Supplementary cost list, item number 1.
May I please, Lordship? Lordship, I rave some accommodation, Lordship. Today, I am having some difficulty, Lordship, today.
How long?
Tomorrow, day after tomorrow, Monday, Lordship.
Monday.
Monday, Lordship, yes, Lordship.
On premier by the Learned Counsel for the petitioner seeking accommodation, matter is adjourned. List the same on Monday. On 16th. Monday 16th.
Lordship.
16th.
Highly
Much obliged, Lordship. On daily cost list, item number 1.
Lordship, this is a contempt matter. We've taken steps and we filed an affidavit also. The respondent number 1 has received the notices on 4/9 and the respondent number 2 on 11/9. I filed bringing on record also the status report.
What is the matter about, Mr. Mugwe?
Your Lordship, this is a matter before Your Lordship had passed a judgment that we should be promoted because we were superseded by the juniors.
Yes. Or those 89
Yes, yes, 89.
Okay.
So now, since February 17th, when the judgment was passed, over 7 months now, it's not been complied. So
No
that's
appeal
why I'm
file.
before your lordship with the contempt
No,
application.
is there any appeal?
Your lordship?
Any appeal file?
Till date, there's no appeal before this court. Before the division bench also. Six weeks direction was passed by this court to comply with the order. So now it's been more than 7-8 months.
Yes. But as far as you know,
And have they received notices also? I don't know why they're avoiding appearance. So my submission is that if they're avoiding your lordship,
this well, as far as respondent 2 is concerned, the CGC would usually appear for him.
who lordship?
CGC or the
Absolutely.
DSDI.
For both of them, it's in fact Mr. Devnath should appear.
Is he aware of this matter?
He is aware.
See, even it may be a contempt matter for that matter, but then in fact, because it is a contempt, the court would be slow in proceeding, ex parte.
Your lordship, only option left is that since they've received notices, so an order may be passed for the personal appearance. They'll have to appear in person and explain why.
Exactly, that will come.
I understand, but if this goes on like this, they don't appear, then
since
we can give them one more opportunity.
When was the? I think let us look at the last order before that.
2 weeks ago, Your Lordship.
On 12/9, services has not been confirmed.
Your Lordship.
And on 27/9, that is when I think we'll give them.
We'll give them.
Mr. Pinongri, Lara Counsel for the petitioner, has submitted that the notices issued upon the respondents 1 and 2 respectively has been affected, and an affidavit of service in this regard has been filed before this court. However, both the respondents have yet to appear before this court. This court would allow the respondent to make their appearance before any order is passed. Any adverse order is passed. Before any order is passed in this regard. On pre-made, list this matter to 3 weeks.
Your Lordship, one additional prayer. Because they have not appeared today, most probably they'll not be aware about this order. So I pray that the said order notice may be issued to them. That the registry will do it, Your Lordship.
As in view of the fact that the respondents are not in attendance before this court today, that copy of this order be issued on them.
On both the respondents.
On them means who?
That is just a clarification.
That means there are only 2 respondents.
Yes.
Fine.
Obliged.
Item number 2.
This item was fixed at the end of the board, Your Honor. It's not present in court.
We are almost at the end of the board in any case. Please, yes, come.
Your Lordship, the brief is not with us, Your Lordship, as the GHJ is still stuck in traffic, Your Lordship.
On premier by the petitioner, let's this matter up to Puja vacation.
Lordship.
Item number 6.
May it please your Lordship. Lordship, I have tried my best to solve the issue, but it appears that the managing committee as well as the person of that particular village, they have refused to accept the apology tendered by the writ petitioner. Your Lordship, to that effect, I have the communication with me.
That's very unfortunate, Your Lordship. She has, despite it's not her fault also, she came to this court, tendered apology also, but the managing committee...
Lordship, may I read it, Your Lordship? If Lordship permits me, I'll read it. Lordship, I'm sorry. I just today I got the
information.
Please. Information. May I read it? Lordship will permit me to read.
Please, please.
This is a letter from Subdivisional School Education Officer Shillong. It was addressed to me, Your Lordship. Then, sir, with reference to the subject cited above and in continuation of today's office, letter number so dated 25 August 2023, I have the honor to inform you that even though the representative of the village Dorba Shnong of Domskong had been highlighted and made them aware by this office on the stay order dated so passed by the Honorable High Court of Meghalaya and its consequence during the meeting held on 23rd August 2023 in the office of the undersigned, so that the stakeholder should be aware of and respect the same, but the Dorbationong of Domscom had informed to this office that they are reluctant to accept the letter of apology tendered by the assistant teacher, Shimati so-and-so, which resulted to hurdles where the two teachers are unable to perform their duties till date and the school is still remain closed. So, Your Lordship, there is a letter also written by the Secretary Domskong and the village headman, Your Lordship. This was addressed to the writ petitioner, Your Lordship, regarding the decision made by the Dorbar, Your Lordship. So, in that view of the matter, Your Lordship, the matter will have to be decided on merits.
Your Lordship, I'm representing the managing committee, so we'll be filing the affidavit in 2 weeks, Your Lordship. Just yesterday, we have also received the copy.
Affidavit?
Last order was directed us to file affidavit, Your Lordship.
I have filed an affidavit bringing on record the letter which I have submitted before the village Darbar regarding my apologies.
So that letter will suffice.
That letter is understood now because they don't want to really come to some sort of a settlement for the betterment of the village, Lordship.
Mr. You have to place that on record.
Lordship, if on the next day the matter may be taken up, then we will furnish all this to all of them, Your Lordship. And will be.
Matter has not been heard.
No, not yet, Your Lordship. Only a proposal has
take
been.
Up the issue on
because the matter now it has to be heard only in some legal issues.
Because last time when it came up, Your Lordship, I had requested. Yes, Your Lordship will recall. So I try my best, Your Lordship. I try my best.
Very adamant, the managing committee plus the village Darbar.
I took the
and
initiative.
It seems, Your Lordship, not mistaken, the managing committee also, the term has expired.
So what do we do?
If that be done,
there's always a chance for the school to reopen, but it's because of the managing committee and the village. Because now the next academic starts, if they start to reopening, students will come and enroll, Your Lordship. But maybe there's some other some extraneous consideration why they don't want to really open up the school again.
See that aspect of the matter, whether the managing committee, if the term has expired, whether they would,
they'll be in a better place to inform your lordship.
Your lordship, the document we have received yesterday, they also held a meeting with the student, with the parents. Even none of the parents are ready to take back the teacher, Your Honor. Reason best known to them. So we'll be filing affidavit stating with all the reason, Your Lordship.
Well, that you can state in your
affidavit, yes, Your Lordship.
In your argument.
Argument, Your Lordship.
We're talking about the terms of the term of the managing committee.
Yes.
Whether it has expired or
it has expired, Your Lordship. But till now, because of the pending of the case, so they have not renewed the committee, Your Lordship.
Do that. The communication has to come from the direction has to come from the state.
Lordship will to that for that specific we'll need we'll have the instruction from the competent authority, Your Lordship. Then we'll come back before Your Lordship on the next stage, Your Lordship. We'll inform Your Lordship accordingly.
But there are counsel of the parties. You give me that copy, Mr. Industrial under EAJ has brought to the notice of this court a communication from the in charge Subdivisional School Education Officer, Shillong, pertaining to the issue, subject matter of the list before this court, inasmuch as on the proposed course of action, course of action to be taken by the parties involved, particularly the managing committee of the said school, to accommodate the petitioner by taking cognizance and accepting the letter filed by the petitioner before the said committee, tendering personal apology the communication would reveal that the managing committee has refused to accept such refuse to accept the apology tendered by the petitioner. Thus rendering the matter to proceed further as far as the reconciliation process is concerned. Be that as it may, since the effort to allow the parties to come to an amicable solution or settlement has failed, it is the submission of the parties that this matter may be finally heard on merits. The Land Council petition has also submitted that it appears that the term of the managing committee, respondent number
5, Your Lordship.
Respondent number 5 has since expired. Though the Land Council for the managing committee has no specific instructions in this regard, the learned AAJ has submitted that he may be allowed to seek instruction as far as the authorities are concerned, and to apprise this court of the situation on the next date of hearing. Just give a photocopy of this.
Lordship, certainly I'll do that, Your Lordship.
On pre-meet, this is matter up to 3 weeks.
Obliged.
Obliged, Your Lordship. I'll keep it.
Item number 9.
What is required here?
Your Lordship, as per the last. If I can just point out, Your Lordship, date of order 12/7/2023, Your Lordship. Your Lordship, it seems that the petitioner, they have submitted that they want to file an affidavit, as there were some judgments which have been rendered by the Guwahati High Court, Your Lordship.
Oh. This has not been done. None appears for the petitioner. Learned counsel for the respondent has brought to the notice of this court the order dated 12/7/2023 passed in this case, wherein the wherein this court had noted the prayer of the petitioner to produce some judgment which are relevant to the subject matter herein. The same has not yet been done till date. Accordingly, the petitioner is directed to produce such judgment or relevant authorities for this matter to proceed further. On pre-meet, this is matter up to 3 weeks.
Much obliged, Lordship.
Mr. Jindal, I'm told that
it's in the process of being filed, my lord.
Oh.
The notary was not available. Notary has just come, my lord. We'll inform Honorable Court once.
Okay,
once
we'll do
it
one thing.
reaches.
Then we'll. If it is done, then I'll come back.
Very good. Within 10 minutes should
What's
be
the point of meeting? The live already so.
May it please you, Lordship.
Where is the caveat? Okay.
Caveat is here.
Yes.
My Lord, first of all, Lordship will allow me to express my deep gratitude that Lordship has given us this indulgence. Because of the circumstances and the urgency, we were forced to ask for this kindness from my Lord. I'll just take 2-3 minutes, my Lord, just to place 2-3 important facts. Just 2-3 minutes, my Lord. My Lord, the issue, the case concerns the golf course area of Shillong. Golf course is run by the Shillong Club Limited, the appellant, my Lord. Now, appellant, the Shillong Club Limited, took the various portions of the golf course on perpetual lease, that means permanent lease, from various clans. All this was done, my Lord, before independence in the 1910, 1920, around that time, my Lord. So various portions of the golf course are on lease from various clans. One portion, my Lord, is from the clan of the respondents. Now, clan of the respondents, my Lord, surprisingly, a few years back, they started attempting to take back certain portion of the land that they had given to us on lease. They sent letters to us. They started advertising in the local newspapers saying that land is there for sale, etc. So to try and stop all those activities, because there was no right of termination that was granted to the clans. If I can take my Lord's attention to the lease deed, my Lord. Lordship, we've prepared a small compilation of documents because there was less time to attach the documents. Page 18 of the compilation, my Lord.
You've given him a copy?
I've given them.
Yes.
Page 18, my Lord, is the lease deed that appellant I entered into.
Yes.
Page 18, my Lord, is my lease deed from 1923, my Lord. Lordship will see on the first page itself, just below the schedule, does hereby lease in perpetuity, my Lord, the said land covering an area of 10.19 acres. So in 1923, they gave us 10.19 acres, my Lord. And another important fact, another important feature of this lease deed, page 20, my Lord, next page. Subclause H, my Lord, the lessee, that means I, shall be entitled to relinquish this lease at any time on giving not less than 1 year's notice to the lessor, his heirs, successors, and interests on assigns. So I, the lessee, was given the right to terminate this lease deed for any reason. The comparable right of termination was not given to them. So because it was a perpetual lease deed and we were supposed to set up a golf course, so they were not given the right to terminate. In spite of this absence of right, they tried. They tried to send us letters, they put advertisements in the papers, etc. To try and stop them, my Lord, we filed a title suit. If Lordship kindly looks at page 39 of this compilation. Title suit, my Lord, was filed in 2013. Page 39 of my compilation is the prayer in my original title suit. Prayer number 1, my Lord. Declaration that the plaintiff Shillong Club Limited is a lawful lessee in respect of the suit property and holds the suit property under a valid perpetual lease deed. Number 2, declaration that the defendant or any of his agents, associates, so-and-so, 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 or any person claiming under or through the defendant have no right to disturb the peaceful possession of the suit property or any portion thereof. Then it goes on, my Lord. So essentially we wanted certain declarations from the suit court, the first court, my Lord. Against my plaint, against this plaint, my Lord, there was a written statement filed by them. The entire case, entire defense which they had is at page 44 of the compilation. Page 44, my Lord, is part of the WS. Para 14, my Lord, I'll read the second paragraph. In reply, my Lord.
Yes.
In reply, it is stated that the predecessors in interest of the defendant on 20th October 1914, that is important, my Lord, leased 16.91 acres of their land to the predecessors in interest of the plaintiff's club. Thereafter, due to bona fide requirement and on mutual understanding, 6 acres of the land situated to the south of the leased land was taken back by the predecessors in interest of the defendant, and a fresh lease deed dated 20th March 1923 was executed only for an area of 10.91 acres as an annexure so-and-so of the plaint. This is their case, my lord. Their case is, according to them, our case is 1923, we took 10.19 acres. As simple as that. Their case is slightly different. Their case is, according to them, in 1914, they gave us 16 acres, 16.91 acres in 1914. Then, according to them, in 1923, they took back 6 acres and gave us only 10.91 acres. So, that was their case. The finding of the suit court, the judgment of the suit court, my lord, page 65. And this is the entire dispute. We are saying in 1923, you gave us 10.9. They're saying no, in 1914, through another lease deed, we gave you 16.9. 1923, we took back 6 acres, and that is the disputed property now. Now, page 65.
So the disputed property is that 6 acre.
6 acres. So according to them, they are entitled to 6 acres of the property of the Shillong Club, and they, based on nothing, they have identified a certain 6 acres area. This is, Lordship may be aware, on the ground, my lord, behind Marin's restaurant on the golf course, there is a forest area. There is no building, etc. It comes to roughly 6 acres. That is the portion they are claiming. So according to them, 1914, we gave you 16, they gave us 16.9. According to them, 1923, they took back that forested area. So now they want possession of that forested area. So finding of the suit court, my lord. Page 65, para 10, my lord. Issue number 3. I'll read, my lord. PW Shri Parambir Singh, on his deposition on an affidavit, stated that the lease deed dated so-and-so, 1914, which is Exhibit A, is not related to the plaintiff's club in any manner, and he has reiterated in his cross-examination that the Shillong Club was incorporated as a limited company and registered under the Companies Act 1923 only on 1/8/1923. This court also perused the Exhibit A, the lease deed dated 2010-1914, and found that this lease deed was between, this is important, my lord, was between the predecessor in interest of the defendant and the secretary to the Shillong Sports Club. Not Shillong Club, my lord. Shillong Sports Club and not the Shillong Club. This court has also perused Annexure 1 and also perused Papermark A, which is the lease deed between the predecessors in interest of the defendant and the plaintiff club for an area of 10.19 acres of land. After perusing both these lease deeds dated 1914, which is Exhibit A, and lease deed dated 1914, which is Annexure 1 and Papermark A, that should be 1923 actually. This court found that the lease deed dated 2010-1914 is not between the plaintiff club and the defendant, but the lease deed dated 23-1923 is the lease deed between the plaintiff club and the defendant for an area of 10.19 acres. So, there is no question of the 6 acres of land situated at the south of the golf club being reverted back to the defendant since 1923. Very clear finding, my lord, that number 1, 1914 document, lease deed, was not between Shillong Club and the defendants. It was between some other entity called Shillong Sports Club. Number 1. Number 2, the lease deed that exists between the party has been upheld. The 1923 lease deed is the lease deed through which 10.91 acres has been given. So, suit court, my lord, said 1914, there is no question. There is no question that 6 acres was given back in 1923. Number 2, 1923 document is the correct document. Now, in spite of this finding, surprisingly, the suit was dismissed. Next page, my lord, para 14. Under the present circumstances of the case and on the basis of the decision arrived at the previous issues, it is redundant to discuss further on the present issue. The plaintiff is not entitled to reliefs under the present circumstances of the case. Very surprising finding. We challenged this finding by filing a first appeal, my lord. Now,
your prayer is confined only to that.
Yes, ma'am.
10.19.
10.19, and she found that yes, you have a document, a valid document for 10.19, but in spite of that, my suit was dismissed. Surprisingly, in any event, we filed an appeal, a first appeal against this judgment, my lord. Now, what is very important, my lord, is that there was no counterclaim filed by them. And when we filed the appeal, there was no cross appeal also filed by them. So in that situation, we filed an appeal. Appeal court processed the matter, took a long time. Finally, 2-3 days back, the impugned judgment was passed, my lord. Now, impugned judgment, if Lordship looks at my memo of appeal, not the compilation, the memo of appeal, my lord.
Yes.
Now, Lordship, I reiterate, there was no cross appeal filed, no counterclaim, nothing. In the impugned judgment, if Lordship kindly looks at page para 89 of the judgment, that is at page 46, para 88 actually, page 46 of the appeal memo, my lord. I'll read para 88, my lord, because a lot of discussion is there. Most of it, with all due respect, is not very, it cannot be understood, but para 88 is where the reasoning is there. It may be pointed out, para 88, my lord, it may be pointed out that the vast tracts of land which was leased out to the appellant plaintiff club by the defendant respondent is situated outside normal area of Shillong, and it falls under the Assam Frontier Tracts Regulation 1880 at the time when the lease deed dated 23/1923 was executed. The said tracts of land was declared as a backward tracts by notification published in 1929 under the Government of India Act 1915-19, where it is stated that the laws shall not apply to the said territories or any part thereof, or shall apply thereto subject to such exceptions and modifications as the governor may think fit. Lordship, I'll just pause, my lord. In this paragraph, First Appeal Court makes a reference to something called Assam Frontier Tracts Regulation of 1880. Now, Lordship, I say this with all the respect at my disposal, but I have never heard of this. During the many years that this case has been pending, we never brought up this issue. They never brought up this issue. So if Lordship asks them also, even they don't know what is this. Assam Frontier Tracts Regulation. Last evening, a colleague of mine spent 3.5 hours trying to locate this regulation of 1880 from every available source. We could not locate. So we, frankly, my lord, I have to place this. We do not know what is this Assam Tract Regulation that learned court below has referred to. He also refers to a notification published in 1929. What is that notification? Who published it? Who issued it? My lord, frankly, we are not aware, my lord. We are not aware. The learned court below should have at least extracted that regulation, the relevant portion. Nothing was done. In any event, my lord, para 89. In view of the said notification noted above, the Transfer of Property Act 1882 is applicable only within the territorial jurisdiction of the Shillong Municipality and Cantonment. The Transfer of Property Act 1882 has not been declared to be in force outside the normal areas of Shillong at the time when the lease deed dated 23/1923 was executed between the parties. The lease deed dated 23/1923 is not a valid lease deed, as the Transfer of Property Act 1882 is not in force in territorial jurisdiction where the landed property is situated. So, Lordship, again I'll pause. Based on this Frontier Regulation of 1880, which we don't know what it says, learned First Appellate Court says the Transfer of Property Act does not apply to that area, did not apply at that time to that area. Therefore, even if you entered into a lease deed, the lease deed is not, in 1923 is not a valid lease deed. He has declared my lease deed itself as invalid. Based on what, my lord? A regulation. With all due respect, I state this. Did anybody ask him to decide that issue?
So was there any issue framed on these lines?
No, absolutely no issue.
With regard to the validity of the...
No, my lord, no. If Lordship recalls, suit court said my 1923 lease was valid, but in spite of that, my suit was dismissed. Anyways, then I filed an appeal. There was no cross appeal. By saying that my lease deed itself is invalid, that means entire 10.19, they want 6 acres. Now he says my entire 10.19 is invalid. I am not entitled to 10.19. On whose prayer was this relief given? They did not file any cross appeal. Now, this one line has the effect of giving them the entire 10.19 acres. They wanted 6 acres. They wanted the sky. They've got the sky, sun, moon, everything else, my lord, based on no prayer, my lord. This is where we stand, my lord. There are other reasons which have been given. Again, I could not really understand the reasoning of the learned court below, but this is where we are stuck, my lord. My entire lease deed has been declared to be invalid. Based on this document, I have 5 more lease deeds. Everyone will come and take possession. The moment this judgment comes to the public's notice, which it will, in 1 or 2 days, everyone will come to take possession of their respective lands. There will be no more golf course in Shillong, my lord. Because of the nature of the judgment that has been passed, I have taken the liberty of respectfully suggesting certain substantial questions of law, my lord. If lordship kindly looks at my memo of appeal, in the synopsis itself, I have put down these questions. And of course, these are just suggestions. Ultimately, my lord has to frame the questions, my lord. Page B, my lord, of the synopsis. Page B, I've suggested 4 questions. Number A, whether a perpetual lease deed entered into between parties is capable of being terminated by a party when no right of termination has been vested on that party, because they tried that. B, my lord, whether a first appellate court can grant relief to the respondent in the appeal in the absence of a counterclaim cross appeal, because that is exactly what has happened. Question C, my lord, whether the provisions of the Transfer of Property Act 1882 have no application over the tribal areas of the state of Meghalaya in view of the operation of the Assam Frontier Tracts Regulation 1880. And this is a very big question, my lord, because not just my lease, my many 5-6 lease agreements, I'm sure there are many other sale deeds, lease agreements, lease deeds, which should be called into question, which should be overturned because of this finding, my lord. And last question, which I've humbly suggested, my lord, whether a court can disregard a copy of an agreement executed between the parties when there is no dispute between the parties about the execution of that agreement. Why this question, my lord, is because at one point later in the judgment, learned first appellate court says, I will not even take the 1923 document into consideration because we produced a paper mark. We didn't produce the original exhibit. Now, that document is not in dispute. They are not disputing that they entered into 1923 document. I am certainly not disputing. So under Evidence Act, something that is not in dispute need not be proved also. So I produced a paper mark. So learned first appellate court said, no, you should have produced the original. It is not in dispute. It is not in dispute. So this is where we stand, my lord. There are substantial questions to be decided. It will take time. Paper mark, paper book, etc. will have to be prepared properly. For the moment, my lord, what is happening is something very disturbing. Respondent, my lord, has approached the Darbar Shillong yesterday, saying that please be informed, we will be coming to take possession because our Shillong Club's appeal is dismissed by the lower court. So Darbar Shillong told them, show me a copy of the order. They said, we'll come back tomorrow when we have a copy. So last evening I got a copy, possibly they also got a copy. So today, even as I am making submissions, my lord, there is police on the ground, there is a crowd on the ground. Frankly, I don't know what exactly is going on, but this is exactly what had happened in 2015 when my suit also got dismissed, my lord. I do not know whether there is a misunderstanding of the law on the part of the respondents, with all due respect. There is no counterclaim, there is no countersuit, nothing has been declared in their favor. They are not declared to be in possession or the owners, etc. Simply because my suit got dismissed in 2015, they landed on 23rd December. Last working day of the lower court, my suit got dismissed, judgment was passed. I filed an appeal immediately that day. 24th, 25th was Christmas. 26th, they came with a JCB to take possession. We showed them the copy of the stay order of the appellate court. They went away. They tried. Today also they are trying. So there is a requirement, my lord, to stay this order, my lord. On the face of it, my lord, this order is a dangerous order, my lord. It cannot be.
Mr. General,
Yes, my lord.
Let us hear the
Very well.
Very the respondent.
Very
Your Lordship, we have just received the copies. We have not yet gone through the contents. No. Lordship, let this matter come after a week. Lordship. This premises. Particular councillors.
Okay, the court will hear that. But now we are on the subject of an interim release.
They can take time. Obviously, they require time, 1 2 weeks, whatever.
But you know, Mr. General, in fact, you would be the better person to advise.
Yes, my lord.
To advise this court.
Yes, my lord.
The provision of law.
Yes, my lord.
When it comes to second appeal.
Yes, my lord.
There is no issue of interim relief.
Without
framing substantial questions of law.
Yes, ma'am.
So firstly, the appeal has to be admitted.
Yes, ma'am.
If it is to be admitted, then the substantial questions of law has to be framed.
Yes, ma'am.
Prior to that.
Yes, ma'am.
And then it goes on.
Yes, ma'am.
Thereafter, then the issue of interim relief.
Yes, ma'am.
Of course, you can take recourse to Order 41 Rule 5(3).
Yes, ma'am.
But then, even then.
Yes, ma'am. Lordship, if Lordship kindly allows me to differ just a little bit, Lordship may kindly look at the CPC Order 42 Rule 1 and 2, my lord.
Even Order 42 Rule 1 and 2 says, okay, fine.
Rule 1, my lord. Order 42, Rule 1. If Lordship has...
Yes.
The rules of Order 41 shall apply as far as may be to appeals from appellate decrees. So as far as second appeals are concerned, the same rules as normal appeals, first appeals will apply. Now, if Lordship looks at Order 41, appellate court has been granted the power to order for a stay. Now, what Lordship has described the procedure that first admit the appeal, then formulate questions of law, etc., then consider the interim. Lordship, I say this with all respect, but there is no procedure as such in the way that Lordship has described.
Yes, true, but there are canon of judgment which says so.
Lordship. So the admission of the appeal, Lordship, in my respectful submission, should not be a problem, because on the face of it,
yes,
on the face of it, there is
the appeal can be admitted, but you see, subject to the court having heard the parties.
Lordship.
He is not in a position to be heard.
Lordship.
Number one.
Lordship.
If that is the case, then the issue of admission of this appeal will not come.
Lordship, the reason he is standing here today is because he has filed a caveat. Now, by filing a caveat, my lord, with all due respect, he cannot hijack these proceedings and stand in the way of a stay order by simply saying, I am not prepared. So he should not file. He shouldn't have filed a caveat if he was not to be prepared. These are not new things. These are all from the records. He is aware of the judgment. He is aware of everything, my lord. So I am only placing before my lord the reality on the ground, my lord. The reality on the ground is such that unless there is a stay, even a limited stay till the next date, if Lordship is inclined, there will be chaos on the ground, and we will be non-supervised.
See, I think the court would appreciate that aspect of the matter.
Yes, my lord.
But again, the court cannot proceed on the premise of sympathy.
Absolutely. We are not asking for... No, that is not the only plank, my lord.
Yes,
that is not the only plank. The illegality of the order, the dangerous precedent that it is attempting to set is very apparent. I am confident Lordship has also seen it. Now, Lordship is saying that the only impediment is that first it has to be admitted. Admission can be done, my lord. Caveat has been discharged.
But if it is to be admitted, then the questions of a substantial question of law has to be framed.
It has to be framed,
and for that, you see, you have given your suggested
my lord.
Issues or questions of substantial questions of law.
Yes, my lord.
They will also have to do it.
Yes, my lord.
And the court will consider what on the basis of pleadings or whatever is on record.
Yes, my lord.
But at this point of time, whether the court can issue an interim order.
Because as far as substantial...
Have you gone through this? I've noted down a judgment.
Yes, my lord.
Have you gone through this judgment?
Yes, my lord.
Raghavendra Swami Mat
Okay.
Versus Uttarandi. This is 2016 or 11.
11.
SEC 235.
235, my lord. Okay.
This is an authority. Of course, there are others.
Yes, my lord.
But do you have it there with you?
No, my lord.
I'll show it to you.
Yes, my lord.
Just read para 18.
Yes, ma'am. I'll read, my lord. In the instant case, the High Court has not yet admitted the matter. It is not in dispute that no substantial question of law has been formulated as it could not have been when the appeal has not been admitted. We say so, as appeal under Section 100 CPC is required to be admitted only on substantial questions of law. It cannot be formal admission like an appeal under Section 96 CPC. That is the fundamental imperative. It is preemptory in character, and that makes the principle absolutely cardinal. The issue that arises for consideration is whether the High Court, without admitting the second appeal, could have entertained I number so-and-so, which was filed seeking interim relief. In Ramphal, from which Mr. Nariman, learned senior counsel, has drawn immense inspiration, the two-judge bench was dealing with a case where the High Court had granted an interim order by staying the execution of the decree but had not framed the substantial question of law. In that context, the court held, however, the High Court granted interim order by staying the execution of the decree. It is against the said order granting interim relief. The respondent in the second appeal has preferred this appeal. This court on a number of occasions has repeatedly held that the High Court acquires jurisdiction to decide the second appeal or deal with the second appeal on merits only when it frames a substantial question of law as required to be framed under Section 100 of the CPC. In the present case, what we find is that the High Court granted interim order and thereafter fixed the matter for framing question of law on a subsequent date. This was not the way to deal with the matter as contemplated under Section 100 CPC. The High Court is required to frame the question of law first and thereafter deal with this matter. Since the High Court dealt with the matter contrary to the mandate enshrined under Section 100 CPC, the impugned order deserves to be set aside. I bow down to this, my lord. I bow down to this. If I can draw Lordship's attention to Section 100 to answer the question whether they have to be heard before Lordship can frame a question of law.
Yes.
Section 100, my lord, subsection 3. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. So I have stated certain questions. 4, my lord, where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. Number 5, the appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeals, that means after the formulation of the question, be allowed to argue that the case does not involve such question. So first question has to be framed by my lord. Only then at the hearing of the appeal they can argue that this question is incorrect, it should not have been framed, etc. So they do not have to be heard for the framing of the question. Now, as far as framing of the question is concerned, my lord, as Lordship has seen, I've suggested 4 questions. From these 4 questions, I am prepared to make a submission, my lord, that only one question is the real question, my lord. That is question number C. Lordship looks at the questions that is at page B.
Yes.
Oh, actually 2 questions, my lord. B. Question number B, whether a first appellate court can grant relief to the respondent in the appeal in the absence of a counterclaim, cross appeal.
Even this issue,
yes, ma'am.
I believe I am not so.
Yes, ma'am. Yes, ma'am.
At this point of time, we are, maybe you may be aware, I may not be aware.
Yes, ma'am.
Whether this issue has been dealt with in any of the decision, or there could have been a precedent, so to say.
Yes, ma'am.
If that is the case, then it cannot constitute substantial question of law.
No, because my lord, I submit, I humbly point out that this is a very logical position. If they have not filed a cross appeal or a cross claim, counterclaim, you cannot give them any relief. But in spite of that, the first appellate court has gone and given them full relief. So the question of law arises that did the learned First Appellate Court have the power to grant relief in the absence of a cross appeal, my lord? And this is something that has, in 21 years of practice, my lord, I have not come across any precedent on this where the court has done that, my lord, that in the absence of a prayer, some relief has been granted, my lord. This is one possible question of law. The other one, my lord, is the one of more importance, whether the provisions of the Transfer of Property Act 1882 have no application over the tribal areas of the state of Meghalaya in view of the operation of the Assam so-and-so regulation 1880, because that is what the trial court is saying.
Even this issue has not been dealt with in.
I have done
any.
No, I have done, as I said, 3.5 hours of research last night just on this, because it came as a shock to me. What is this regulation? 3.5 hours, me and my colleagues spent trying to find something about this. Not a single judgment is there. Not a single reference is there. Does it actually exist also? I, frankly, my lord, do not know. But my entire case, my entire appeal has been dismissed because of this, saying that there is a regulation, some notification under that regulation of 1919, I think. And as per the regulation, TP Act does not apply. Therefore, your entire lease itself is a invalid document. So this is a substantial question because, as I said some time back, this finding of the court will affect not just me. I am sure it affects tens and hundreds of other people, because a lot of instances, Lordship also is aware of lease deeds, gift deeds, sale deeds being executed during that period before independence. Now, all those documents have been declared as invalid through this one innocuous line, my lord. This, my lord, is the substantial question. So I would humbly pray, my lord, that it's a imposition that I'm putting on this honorable court. If my appeal could be admitted, for which there is no problem, and at the same time, my lord, a substantial question, that is question number C, that can be framed. If there is some addition to be made subsequently, there is nothing that prohibits further substantial questions being added or modifications being made. They are not required to be heard as per section 100 at this stage on that substantial question. If Lordship could kindly frame that substantial question, that is question number C, and stay the operation of this order, my lord. Frankly, my lord, Lordship would have noticed by now, more than the issues of law, I am more interested, my lord, in stopping that chaos which is going on in the ground. If Lordship could kindly take the trouble of framing that, admitting the appeal, framing this question number C, I am granting a stay, my lord.
Yes, what do you say?
Conducting counsel is not is a personal difficulty, so your lordship maybe after 1 week, lordship, to be heard, because I'm not the conducting counsel here.
No, in that case, since you have you have entered appearance, you have filed the caveat. Caveat is to be discharged. So effectively, no notice is required to be issued upon you. You have received copy of the memo of appeal, and the urgency is there, no doubt. And also the fact remains that this is a matter which is not within the roster of this court.
True, my lord. True, my lord.
In any case, this goes back to the regular court.
True, my lord. Because of the peculiar circumstance where Lord Justice Thank was leaving for somewhere, he advised me, in fact, that please go immediately to Justice Dindo and make a request. It will go back to Justice Thank, but for today, my lord, some protection is required.
After a week, my lord.
Fine, we'll take it up. Court will take it up. Then I think the stay order has to be there.
Yes, my lord. Till the next date. That is
till the next date.
Very good.
After that, you can always file for recall of the order or vacation or whatever. So there is no, of course, there's no objection to you for admission of the appeal. It's a matter of course. But Mr. S. General Counsel for the appellant. was submitted that the appellant as plaintiff has instituted a title suit being TS number 13T of 2013 before the court of the Learned Assistant to the Deputy Commissioner Shillong. Where is the copy of the suit?
My lord, at page 39, my lord. 30 onwards, prayer is at 39. Compilation, my lord.
Going to the last line. Being a suit for declaration, permanent injunction and other consequential relief. Under bracket S. The defendant therein being the respondent in this case, in this appeal, in this second appeal. The prayer in the said title suit the main prayer in the said title suit being the following: item 1 and 2. In due course, the suit was heard, and the trial court took up the suit for hearing, and eventually, by the impugn order dated. Where is the impugn?
23/12/2015.
Where is it?
Lordship, that is at page 65. The relevant portion, it starts from page 60.
Going to 2015 had dismissed the suit being aggrieved by such dismissal. The appellant has then preferred an appeal before the first appellate court, and the being registered as, this is TCA.
Yes, my lord.
TCA number 1 under bracket T of 2015. The Learned First Appellate Court had accordingly taken up the hearing of the matter, and finally, on conclusion of the argument made by the parties, have by order dated 1/4. Is it 1/4/2016?
No, my lord. The impugned judgment is 5th October.
Where is it?
That is at page 21 of my memo, my lord. Memo of appeal. Page 21.
Okay.
Page 22 reflects the order, my lord. The date of order.
By order dated 5/10/2023 has dismissed the appeal. At this juncture, the court would not go into discussion of the impugned judgment, except to say that the case of the appellant herein has been dislodged at 2 stages. Firstly, before the trial court, and secondly, before the first appellate court. Hence, this appeal. Hence, this second appeal. It is the submission of Mr. Jindal that there are substantial issues of law involved, which would allow this court to exercise its jurisdiction, particularly under section 100 CPC, and such an some of the probable substantial questions of law have been suggested, which appears in the memo of appeal. This is part of your synopsis.
Synopsis. It is also there in the main.
Should be. Where is
it is there, my lord. Page 12, my lord. Page 12, para 4, my lord.
Page 12. At page 12, comma, para 4 of the memo of appeal. Only memo of appeal. At page 12, para 4. And at para 4 of page 12. I dash 13. No? Another submission made by the learned counsel for the appellant is that since the dispute between the parties pertains to a landed property situated at, where is it situated?
Golf links, my lord.
It's called Golf Links, Shillong. By virtue of the said impugned judgment, whereby the perpetual lease deed entered into between the parties who are the predecessor in interest of the appellant and the respondents herein. The said lease deed being dated. Where is the what is the date of that lease deed?
It's my lord, it's
that the 23 one
2003/1923.
20/03/1923. Unang tungkol? Was declared redundant and by the First Appellate Court. The situation has thus emerged that the respondent has now claimed ownership over the same, and in the process has according to the information and knowledge, according to the knowledge and information of the appellant, sought to take over possession of the said land in question without following due process of law, which at this point of time it is imperative that the action of the respondent be stopped by passing of an interim order to such effect, to this effect. Next. The respondent has also entered appearance through direct counsel,
Mr. M. Marwan,
who has submitted that a caveat has been filed in this case, which on his appearance is accordingly discharged. The direct counsel has, however, submitted that the conducting counsel, who is seasoned of this matter, is personally indisposed and has sought for some time for this matter to be heard. This court has given due consideration to the submission made and is also considered the submission made by the direct counsel for the appellant as far as the prayer for interim relief is concerned. Be that as it may, at the first instance, on perusal of the memo of appeal, this court is convinced that the appeal is required to be admitted and is done so here accordingly. Secondly, on admission of the appeal, of the second appeal, the court would agree with the suggestion made by the appellant as far as the substantial question of law is concerned, and would also agree that at this point of time, two of the suggested substantial questions of law are required to be formulated herein. This same being, you say it's a number B and C, or C and D?
B and C, my lord. More C, but if lordship is convinced on B also. But C definitely, obviously, my lord.
B and C found at page 13 of the memo of appeal. The same being reproduced herein and as follows. Next, on admission of this appeal, thereafter the question of interim relief is taken up. However, this court at this juncture would prefer that the issue be heard in the presence of the parties concerned, taking into account the submission made by the learned counsel for the respondent at the bar. However, in view of the urgency of the matter, in view of the urgency and sensitivity of the matter, as was urged upon by the learned counsel for the appellant, at this stage the court would allow the prayer to the extent that the operation of the impugned judgment and order dated, just the date again,
Lordship, TCA number 1T 2015,
dated
dated 5th October 2023.
Dated 5th October 2023 is hereby state until the next date fixed for this matter, to which the respondent is allowed to The respondent is, however, allowed to be heard and allowed to file any application for alteration or modification of interim order, which will be taken up for hearing in due course. We'll list the matter on 16th.
Lordship, because since Lordship has admitted this, the next stage, my Lord, would be preparation of a paper book. Lordship may be required to direct.
That is only for the purpose of that interim. Of course, that will go.
Paper book will have to be prepared. That the office will take some time. So A normal date may be fixed or regular date.
You see, like I said,
Yes, ma'am.
This court is very reluctant to issue the interim order at this stage. But on your submission that there may be question of law and order,
Yes, ma'am. Yes,
so on
ma'am.
and so forth.
Yes, ma'am.
So to that extent,
yes, ma'am.
I'll just note down. Are you sure that there would be a law and order situation?
That is my instruction. That can be recorded, my lord.
That's a thought. Oh, I'll just note it down.
A possibility of law and order situation.
Yeah, possibility. So, yeah, because if this court allow, yes, now it's admitted.
Yes, ma'am.
If the court allows for the procedure to be followed, yes, you have to. The book has to be prepared,
Yes,
and all things, and that will take time.
Yes, ma'am.
But for the interim,
yes, my lord. If I can humbly suggest, my lord, the paper book may be allowed to be prepared in normal course. In the meantime, if respondent chooses, they can file any petition, etc., for alteration, modification of the interim order.
that's what I've
Yes,
noted.
ma'am. So matter may come up in normal course. Enough time may be given for preparation of paper book. Additionally, they can be given the right because
You can do that. In fact, you can. Yeah, yes. I think that is really proper. You can do that in course of a few days or so, and file your application. The matter will be taken up.
Yes, ma'am.
After a week, after Monday.
By Monday, you do. So as submitted by the appellant, by the legal counsel for the appellant, MD has submitted the records of the records before the trial court as well as the first appellate court are hereby directed to be produced for this court within the next date fix. In the meantime, because you see, records have to be produced.
Obviously, ma'am.
Then you prepare the paper book.
Yes, ma'am.
Otherwise, how would you do it?
Naturally.
Without paper book.
Naturally.
So, according for the records, we can do it in a few days' time.
That can be done.
Whereupon, on receipt of the said records, the appellant is at liberty to prepare the paper book. As paper, registry is directed to call for the said records, which should be placed before this court within the next date fix. List this matter on 18th. So,
Lordship.
18th?
Yes, ma'am. Because I believe Justice Thank You is also on leave till 17th or 18th. I'm not very sure, my lord.
Oh yes, maybe on leave till 17th. So
maybe 20th could be the safer date, my lord.
20th,
19th or 20th, because I think he's on leave till 18th. Thereafter, he's joining.
Yes. On 19th, we have a program. We have to go to Joy.
Okay.
For inauguration of the district court there.
Okay.
So list it on 20th.
Or after,
20th, I believe he'll be here.
Or after pujas, if Lordship allows.
Let
us enjoy pujas without any tension.
At the most, he'll come. In fact,
no, Lordship has been very kind. I will not ask for more.
20th, this is
20th. Okay.
I am on your submission.
Yes, ma'am.
This court has indulged you.
Very grateful. I'm very grateful.
Otherwise, I believe.
Otherwise,
if this matter goes up, we set aside.
Yes, my lord. My lordship is very kind. We are very grateful, my
lord. So I think that's it.
Obliged. Highly obliged.